The judge's name was the Honorable Patricia Wainwright, and she had been on the Guilford County Superior Court bench for 19 years. I know this because my attorney told me before we walked into that courtroom, the way an attorney tells you specific facts about a judge before a hearing so that you understand who is going to be in the room and what their presence means. What Karen Aldridge told me about Patricia Wainwright was this. She had a particular intolerance for people who wasted her court's time and a particular memory for the ones who tried to deceive it. She said, "She is not a dramatic person. When she gets very quiet in there, that is when you pay the most attention." I understood that. I noted it. I sat across the aisle from my brother Curtis for the first time in 3 years, and I watched the Honorable Patricia Wainwright open the case file, and I watched her read. The courtroom was not large. Guilford County Superior Court in Greensboro, North Carolina, is a working courtroom, not a theatrical one. Fluorescent light and dark wood, and the particular institutional smell of a building, where serious things happen routinely enough that the building has stopped being impressed by them. My brother sat at the petitioner's table in a charcoal suit I did not recognize, beside an attorney named Franklin Greer, who had the silver-haired competence of someone charging for that competence by the hour. I sat at the respondent's table with Karen Aldridge, who was 52 years old, and who had been handling estate litigation in Guilford County for 24 years, and who had told me on the drive over that the question was not whether we would win, but how quickly. I had not fully believed her until the judge opened the file. Patricia Wainwright read in silence. She turned pages with the deliberate economy of someone who reads legal documents the way other people read weather, looking for the specific information that tells you what is actually happening rather than what the surface appears to show. She reached a specific page. She stopped. She removed her reading glasses and set them on the bench in front of her, with the particular care of someone who wants their hands free. She looked at the petitioner's table. She looked at my brother. She said, and her voice was the voice Karen had described, quiet in the way that quiet means something. "Mr. Whitmore, I need you to explain something to this court. Your signature appears as a witness on the document you have submitted as the amended will of Edward Whitmore, dated March 14th, 2023. The notarization on that document confirms Edward Whitmore's signature was applied on March 14th, 2023, but the digital metadata embedded in the document file, which your opposing counsel has entered into evidence, indicates the file was created on February 28, 2023, and your witness signature, Mr. Whitmore, is embedded in that file's creation layer." She stopped. She let that sit in the room for a moment. Then she said, "Explain to this court how your signature appears on a document your father hadn't signed yet." My brother sat very still. His attorney put a hand on his arm. My brother looked at the hand, and then at the judge, and then at something in the middle distance between them that was not anything in the room. The silence lasted 11 seconds. I counted. I want to tell you what those 11 seconds felt like, but the truth is they felt like nothing. They felt like completion. They felt like the end of something that had been moving toward this moment for 3 years, and that had arrived exactly where my father had trusted it to arrive. My father had trusted me. He had trusted me with everything, his house, his estate, the company he had built and sold, the careful legal documentation of everything he owned and intended. He had trusted me to hold it correctly after he was gone. He had trusted me to be in this courtroom when it was necessary to be here. I was here. And the document my brother had submitted as proof of my father's changed intentions had just been exposed, by the metadata in its own digital file, as something my father's hand had never touched in the form my brother had presented it. The record was the record, and it was not Curtis's. My name is Michael Whitmore. I am 44 years old. I live in Greensboro, North Carolina. And the 3 years that separated the last conversation I had with my brother, from the moment I sat across from him in that courtroom, were 3 years in which my father built, documented, and prepared everything I needed to walk into that room and win. He did not tell me he was doing it. He just did it, because that is who he was. Welcome to True Story. Hit that subscribe button and drop your city in the comments below. We read every single one. Now let's get into this. My father, Edward James Whitmore, built Whitmore Furniture Manufacturing in Greensboro, North Carolina. From a single warehouse and 4 woodworking machines he had purchased at auction in 1981 for a combined total of $11,000. He was 29 years old, he had a GED, a mechanical aptitude that bordered on structural intelligence, and a stubbornness about quality that cost him business in the short term and built him a reputation in the long term that no marketing budget could have purchased. Whitmore Furniture made commercial and institutional hardwood furniture, chairs, tables, credenzas, conference room sets, the durable and unfussy kind of furniture that ends up in courthouse waiting rooms and university faculty offices and regional hospital conference centers, and that lasts 30 years without requiring attention. That durability was my father's signature in the literal sense. He inspected every piece before it left the warehouse. He had a specific fingernail test for a finish, a specific grip test for a joint, a specific eye-level assessment for a tabletop that he had developed in the first years and never abandoned. He did not delegate the inspection. He did it himself until the company had 60 employees and the volume made it structurally impossible, and then he hired an inspection manager and trained her personally and checked her work randomly for 2 years until he was certain she had internalized what he was looking for. That is the kind of person my father was. He built things that lasted, and he verified them personally, and he did not assume that what looked right was right until he had run his hand over it and confirmed it. He sold Whitmore Furniture in 2018 to a commercial furniture group out of Charlotte for a number I will describe only as comfortable and well-deserved. He was 67 years old. He retired to the house on Fisher Park Circle in Greensboro that he and my mother had bought in 1994, and that he had lived in alone since my mother died of a stroke in 2015. He read history, specifically the histories of people who had built things. He called me on Wednesday evenings and Sunday mornings and came to every significant event in my children's lives without being asked, and stayed longer than the social script required because he liked being there. My mother, Dorothy Whitmore, had been gone since 2015, and I am not going to describe her at length here, because this is my father's story, and my brother's story, and my mother deserves her own, and she will not get a fair version of it inside the borders of this one. What I will tell you is that she was the moral architecture of our family, in the way that some people are the moral architecture of their families, not by asserting it but by being it, and that when she died, the load that she had been carrying quietly became visible only by the changes in how everyone moved without it beneath them. Curtis had already been moving differently for several years before my mother died. Curtis James Whitmore was 46 years old, 2 years older than me, and had spent most of his adult life in a version of the furniture business that was adjacent to our father's, but never quite the same. He had worked at Whitmore Furniture in his 20s, and had left after a disagreement about his role that had been, from my father's perspective, about competence, and from Curtis's perspective, about respect. He had started his own furniture retail operation in 2003, a showroom on Battleground Avenue that sold mid-range commercial furniture to local businesses. It had done reasonably well for a decade, and had then begun doing less well in the way that mid-range retail does less well when the market changes around it. By 2019, the year after our father sold the manufacturing company, Curtis's retail operation was struggling. I do not know the precise state of his finances because Curtis did not discuss his finances with anyone including our father, which is a particular kind of financial privacy that usually means the finances are not something you want discussed. What I know is that he came to my father 3 times in 2019 and 2020, asking for financial support. What I know is that my father provided it twice, to the tune of $60,000 over 2 years, and declined the 3rd time in early 2021, with a specific and documented rationale that he shared with me afterward. He had said, "Michael, I've helped Curtis twice. The money went into the business and didn't change the trajectory. A 3rd time won't change the trajectory either. It'll just move the problem 3 or 4 months down the road, and teach him that the problem has a different solution than the one it actually has." He had said, "I told him I loved him, and that the business answer was no. Curtis had not spoken to our father after that conversation. Not once in the following 2 years. Not a call on his birthday. Not a text at Christmas. Not a visit to the house on Fisher Park Circle, which was 20 minutes from his showroom on Battleground Avenue. 2 years of complete silence, which I understood in the way that you understand something about a person that you have been understanding for a long time, but have not been able to name until the name becomes unavoidable. What Curtis had decided, and what I understood by the silence, was that our father owed him something. Not the $60,000, not the third loan that had been declined, something larger and more fundamental. He had decided that proximity to what our father had built entitled him to a share of it that was larger than whatever our father decided to give him. He had decided that the company's sale proceeds and the Fisher Park Circle house and the careful accumulation of a modest life well lived were things he was owed by right of the relationship rather than by merit of the connection. Our father had declined to agree with that assessment, and Curtis had gone silent. Our father died in September of 2023. He was 74 years old. Congestive heart failure that had been managed for 3 years, and that had finally moved faster than the management. He died in the Fisher Park Circle house, in his bedroom, with me beside him. My 2 children had been with him the week before. His longtime doctor had described his final weeks as peaceful, in the genuine clinical sense of the word, not as a comfort, but as a fact. He had been ready in the way that people who have finished their work and said what they needed to say become ready. I called Curtis the morning after my father died. He answered on the 4th ring. I told him. He said he was sorry. He said he appreciated me calling. He said he would make arrangements to come to the funeral. He came to the funeral. We spoke briefly. He looked at our father in the casket, with an expression I could not entirely read, and that I decided, in the generosity that funerals sometimes produce, to interpret as grief. He left before the reception ended. He did not call in the following days. 6 weeks after my father's funeral, on a Tuesday morning in October, I received a call from Karen Aldridge. I had not hired Karen Aldridge. My father had. This is the detail of the story that I did not understand until Karen explained it to me on that Tuesday morning, and that I have thought about many times since, because it is the detail that most clearly reveals who my father was and how he thought about the things that mattered to him. My father had contacted Karen Aldridge in July of 2023, 2 months before he died, during the period when his cardiologist had told him the trajectory of the heart failure had changed, and that the timeline they had been working with was no longer the reliable one. He had not told me about that conversation with the cardiologist. He had not told me about his call to Karen. What he had done, with the clarity and the specificity of a man who has spent his life verifying what he was building before he left it, was call an estate litigation attorney and ask her a very specific question. He had said, "I have a son who has not spoken to me in 2 years, because I declined to give him a third loan after giving him 2. I expect that when I die he will contest my will. What do I need to do right now to make sure that if he does, the contest fails?" Karen had told me that on the phone on Tuesday morning and had said, "Your father was one of the clearest clients I have ever had in terms of understanding exactly what the problem was and exactly what he needed." She had spent 2 sessions with him in July. What they had built together was this: a comprehensive documentation package to accompany the valid 2022 will that my father's estate attorney, a man named Raymond Voss who had been handling his affairs since 1998, had already drafted. The package included a signed and notarized letter from my father, written in his own hand and then typed and notarized, describing in precise detail his relationship with Curtis, the 2 loans and their amounts, the third declined loan and his reasoning, and the 2 years of subsequent silence. It included bank records showing the $60,000 in outgoing transfers and the 0 incoming contact from Curtis in the 28 months following the declined third loan. It included a letter from Raymond Voss confirming the circumstances under which the 2022 will had been drafted and the complete absence of any subsequent changes to that document. And it included, recorded on my father's iPhone on a Wednesday afternoon in August of 2023, and uploaded to a cloud account Karen controlled, a 14-minute video of my father, sitting in his reading chair, in the Fisher Park Circle living room, speaking directly to the camera, calm and clear, and in full possession of himself, explaining exactly what he owned, exactly how he intended to dispose of it, exactly why Curtis was not a primary beneficiary, and exactly what he thought about the possibility that Curtis would try to contest the document after he was gone. I watched that video for the first time in Karen's office on Madison Avenue on a Tuesday morning in October 2023, 6 weeks after my father died. I watched a man I had watched my whole life sit in a chair I had sat across from my whole life and speak in the voice I had heard my whole life. And I watched him be entirely himself in the way that people are entirely themselves when they know what is coming and have decided to meet it head-on rather than be surprised by it. He said, toward the end of the video, looking directly at the camera, "I want whoever watches this to understand that I love both of my sons. I want that on the record clearly. But love and inheritance are different things, and I have spent my entire working life building a structure that I am entitled to direct as I see fit. My direction is clear. I have documented it. And if Curtis decides to challenge that direction in court, I want him to know that I anticipated it, that I prepared for it, and that the preparation was thorough." He paused. He looked at the camera in the way he used to look at me across the kitchen table, when he had said something that he wanted to make sure had landed. Then he said, "I built things that lasted. This is the last one. It'll hold." I sat in Karen's office, and I watched my father say those words, and I did not cry. I held what I was feeling in the place where you hold things that are too large for the moment, and that you will need to return to when the moment allows. There was work to do first. Karen said, "Your father's documentation is the most complete pre-litigation preparation I have seen a client bring to a potential will contest. He understood exactly what he was building." I said, "He spent 40 years in manufacturing. He knew what a structural failure looked like, and he did not build them." She said, "Curtis filed the contest 3 weeks ago. I held the filing pending our first conversation because your father asked me to. He wanted you to hear from me directly before you heard from the court." I said, "What is Curtis claiming?" She said, "He has submitted a document he describes as an amended will executed by your father on March 14, 2023. The document purports to revise the distribution of the estate to include Curtis as an equal co-beneficiary. He is claiming the 2022 will was signed under undue influence from you and does not reflect your father's true intentions." I said, "My father has 14 minutes of video explaining his true intentions." Karen said, "He does, and there is something else." When our forensic document examiner reviewed the submitted 2023 document, she found something that Curtis is going to need to explain in front of a judge. She opened the folder on her desk and set a document in front of me. A technical analysis report from a forensic document examiner named Dr. Linda Garrett, 4 pages dense with specific findings. Karen pointed to the relevant section on page 2. The document submitted by Curtis as the March 14, 2023 amended will had been created as a digital file on February 28, 2023. That digital creation date was embedded in the file's metadata and was not disputable. The document bore Curtis's signature as a witness to the will execution, dated March 14, 2023. But the forensic analysis of the document's digital structure showed that Curtis's signature, or rather the scanned image of it, had been embedded in the file at the time of the file's original creation, on February 28, not at the time of any subsequent modification. The witness signed the document on February 28. The document was dated March 14. The subject of the will, my father, could not have signed on March 14, a document that his witness had already signed 16 days earlier, on February 28. The sequencing was impossible. The document was fabricated. I read the report. I read it twice. Then I set it down on Karen's desk, and I looked out her window at Madison Avenue, and the ordinary Greensboro Tuesday morning, going about its business. I said, "He signed the witness line on a blank template before he filled in the rest." Karen said, "That is Dr. Garrett's conclusion, yes. He prepared a document, signed the witness line on the template, then completed the content and dated it forward to a date after the template had already been signed. I said, "And my father's signature?" Karen said, "Consistent with forgery in Dr. Garrett's assessment, with several specific indicators. The pressure pattern, the pen lift between letters, and the baseline deviation are all inconsistent with the authenticated samples from the 2022 will and the July 2023 notarized letter. She cannot say with absolute certainty it is a forgery without additional analysis, but the probability is extremely high." I said, "So he created a template, signed it himself, forged our father's signature, dated it forward, and submitted it to court as proof of a changed will." Karen said, "That is what the evidence indicates." I said, "And the 14-minute video." Karen said, "Is the most direct refutation of undue influence I have ever had access to in a will contest case." I said, "What do you need from me?" She said, "I need you to be in that courtroom, and I need you to be as calm in that room as you are in this one." I said, "I have been calm about this since my father made the video. He did the work. I just need to be present for it." She looked at me for a moment. She said, "Your father described you to me in our July meetings. He said you were the kind of person who understood that preparation was not optional. He said it was the thing he was most proud of having given you." I sat with that. Then I said, "When is the hearing?" She said, 3 weeks from Thursday. I want to tell you about the 3 years I had not spoken to my brother before I sat across from him in that courtroom, because those years are part of this story in a way that doesn't get told in the courtroom footage. When Curtis stopped speaking to our father after the declined loan in early 2021, I was not immediately sure how to navigate my own relationship with him. He was my brother. He had been my brother for 44 years, which is a fact that doesn't dissolve in the acid of a family dispute the way that other relationships might. We had shared a childhood, and a father and a mother who was gone, and a history of things that matter, in the specific way that shared history matters. Not as sentiment, but as structural reality. I called Curtis twice in the spring of 2021. He answered the second time. We talked for 20 minutes in the careful way that brothers talk when both of them are avoiding the central thing. He said he was fine. He said the business was fine. He said he appreciated me calling. He did not ask about our father. I mentioned our father once, briefly, and the silence that followed was long enough that I understood the mention had been a mistake and did not repeat it. After that, I sent a text on his birthday in October of 2021. He replied with 2 words, "Thanks, man," which is the minimum quantity of response that technically qualifies as acknowledgement. I sent a text at Christmas. He replied with a single emoji, which is below the minimum quantity of acknowledgement, and which told me that the temperature had dropped in the intervening months rather than risen. I stopped reaching out after that, not in anger, in the recognition that the reaching was not reaching anything. Our father mentioned Curtis rarely in our Wednesday and Sunday calls, and when he did it was with the particular careful neutrality of a man who has made his peace with something and does not want to give it more energy than the peace requires. He said once, on a Wednesday in the spring of 2022, "Michael, I want you to know that whatever happens between Curtis and me, I do not want it to affect how you and he eventually find your way back to each other. That is between the two of you, and it always will be." I said, "I don't know that there is a way back, Dad." He said, "Give it time, and give it space. Both of you need both." I gave it time, I gave it space. I did not know what my father was building in July of 2023, while he was giving his own version of time and space their final accounting. I did not know about Karen Aldridge, or the documentation package, or the 14-minute video. I found out on a Tuesday morning in October when Curtis had already filed a contest and the legal machinery had already begun to move. I drove to the Fisher Park Circle House the evening after I spoke with Karen. I let myself in with the key my father had given me, and that I had not yet had reason to use since the estate paperwork had been completed. The house was exactly as my father had left it, the books on the shelves in the order he maintained, the reading chair angled toward the window the way he always had it, the photographs on the mantel that had been there for decades, My mother and my father at the beach somewhere in the late 1980s, Curtis and I at maybe 12 and 14 with fishing rods, the family at Christmas the year my first child was born. I sat in the reading chair for a while, the chair where he had made the video. I looked at the window he had been looking at when he recorded it. The Fisher Park Circle Yard going gold in the October afternoon, the way it would have gone gold on the August afternoon, when he had sat in this same chair and spoken to a camera and told me, without knowing I was listening yet, that the last thing he built would hold. I called Karen from the chair. I said, "Karen, I need to do something before the hearing, and I need your guidance on whether it's appropriate." She said, "Tell me." I said, "I want to call Curtis, not to discuss the case, not to negotiate. I want to sit across from him before we sit across from each other in that courtroom. I want to give him the chance to withdraw the contest before it goes to a judge. I think he deserves that chance, even if he doesn't take it." She was quiet for a moment. She said, "That is an unusual impulse in this situation." I said, "My father said to give it time and space. I'm honoring that." She said, "I'll call his attorney first and establish parameters. If Franklin Greer agrees to a structured conversation, I'll be present. And Michael, I want you to understand that if you go into that conversation hoping to change your brother's mind, you will be disappointed." I said, "I'm not going to try to change his mind. I'm going to tell him what I know. What he does with it is his." The meeting happened the following week at Karen's office. Curtis came with Franklin Greer. I came with Karen. We sat at the conference table, my brother and I across from each other for the first time in 3 years, and I looked at him the way you look at someone who was a child with you and is now something more complicated. And I said what I had come to say. I said, "Curtis, I need you to know what Dad built, not the will. What he built around the will. I need you to know that there is a video. I need you to know what the forensic examiner found in the document you submitted. And I need to give you the chance to withdraw the contest before the hearing. Because what is going to happen in that courtroom is not going to be a close question, and I would rather you not go through it if there is an alternative." Curtis looked at me across the table. He had aged in 3 years in the way that stress ages a person faster than time. The lines around his eyes deeper, the set of his shoulders carrying something he had been carrying for too long. He looked at me, and he said nothing for a long moment. Then he said, "What video?" I said, "Dad recorded himself in August, 14 minutes, in his reading chair, explaining everything." Franklin Greer touched Curtis's arm. Curtis ignored it. He said, "What does he say in it?" I said, "He says he loves you. He says the inheritance decision is not a reflection of that. He says he anticipated this and that he prepared for it. And Curtis, he says he doesn't want this for you. He says the last time he saw your face before the silence was a Thursday in January 2021, and that he thought about that Thursday more than he thought you'd expect." Something moved across my brother's face. Something that had nothing to do with the legal case, or the contested document, or the forensic examiner's report. Something that was older and quieter than any of that. He said, "He thought about it?" I said, "It's in the video." A silence. Franklin Greer was looking at his legal pad. Karen was looking at her hands. Curtis and I were looking at each other across 3 years and a conference table, and the distance between what we had been and what we had become. He said, "I'm not withdrawing." I said, "Okay." He said, "I need to go through the process." I said, "Okay, Curtis." We did not say anything else of substance. He and Franklin left. Karen and I sat at the table for a few minutes after. She said, "You gave him the chance." I said, "And he needs to understand it for himself. He won't understand it until the judge says it." She said, "Are you ready for Thursday?" I said, "My father was ready in August. I just need to follow his work." In the courtroom on Thursday morning, I watched my brother's attorney, Franklin Greer, present the case for the contested document with the competent professionalism of someone who knows the material and has decided to present it as clearly as possible, regardless of what he privately understands about its evidentiary foundation. He submitted the March 14th document. He submitted the argument that the 2022 will reflected undue influence from me. He submitted a declaration from Curtis, describing his belief that our father's intentions had changed in the final months of his life. Karen responded with Raymond Voss, who was 68 years old, and had been my father's estate attorney for 25 years, and who testified to the circumstances of the 2022 will drafting in the specific unembellished terms of a man who has been a practicing attorney long enough to understand that the truth, presented plainly, is more effective than any ornamentation. He said my father had come to him voluntarily, described his wishes clearly, reviewed the document twice, and signed it with full capacity and no external pressure. He said the document had not been amended at any point after its execution. He said he had no knowledge of and had not participated in the preparation of any document dated March 14, 2023. Then Karen submitted Dr. Linda Garrett's forensic report. She walked through the findings in plain language, the digital creation date of February 28, the embedded signature layer at file creation, the impossibility of the March 14 witnessing sequence. Dr. Garrett was present and answered 3 questions from the judge with the precision of someone who has testified before courts many times and understands that precision is the most useful quality she can bring to a room. Then Karen submitted the video. The screen in the courtroom displayed my father in his reading chair on an August afternoon. The room was quiet in the way that rooms become quiet when something real enters them. My father spoke for 14 minutes. He was clear and specific and calm and entirely himself, and he said exactly what he had told Karen he intended to say. At the end of the video, the screen went dark, and the room stayed quiet for a moment longer than it needed to. Judge Wainwright looked at the file. She made a note. She removed her glasses. She looked at Franklin Greer. She said, "Counsel, your client has submitted as evidence of his father's amended testamentary intent, a document that your opposing counsel's forensic examiner has found to be digitally inconsistent with its stated execution date. I want to hear from your client directly about the preparation and submission of this document." Franklin said, "Your Honor, Mr. Whitmore is prepared to address that." Curtis stood. He looked at the judge. He said, "Your Honor, I believe the document represented my father's true wishes." Judge Wainwright said, "Mr. Whitmore, your signature as witness is embedded in a digital file created 16 days before the date on which that document was purportedly executed by your father. The forensic analysis is specific and has not been credibly rebutted by your counsel. I need you to explain to this court how your signature appears on a document your father hadn't signed yet." 11 seconds of silence. My brother stood at the petitioner's table in a charcoal suit I did not recognize, and he looked at the Honorable Patricia Wainwright, and he did not have an answer. Not because he could not construct one, because there was not one that the room would hold. The document's own digital record had said what it said, and no version of what came next was going to unsay it. Franklin Greer rose and said, "Your Honor, we'd request a brief recess." The judge said, "We'll take 10 minutes." The courtroom stood. My brother walked past me on his way to the hallway. He did not look at me. He looked straight ahead, with the expression of a man who has arrived at the end of something he built, and is registering, in real time, what the construction actually was. Karen put her hand briefly on my arm. She said, very quietly, "It's done." I said, "Not yet." We came back from recess. Franklin Greer stood and said that his client was withdrawing the contest. The judge noted the withdrawal. She made several additional remarks about the submission of fraudulent documentation to the court that I will not reproduce in full here, but that were specific enough and direct enough that I believe Franklin Greer wrote a particular kind of entry in his notes about this case that he will not enjoy reviewing. The 2022 will was confirmed valid. The estate proceeded on its original terms. My father's house, his accounts, the careful remainder of what he had built and sold, all of it went exactly where he had directed it to go on a winter afternoon in 2022, when he had sat across from Raymond Voss and signed his name to a document that said what he meant. I went to the Fisher Park Circle House the evening after the hearing. I had been going every few days since my father died, working through the practical business of an estate, and doing it slowly because slow felt right. There was no urgency. The house was not going anywhere. I sat in the reading chair again. I looked at the window at the November dark outside, and I thought about August and a phone he had pointed at himself, and 14 minutes of clear, unambiguous, completely characteristic Edward Whitmore. He had built a thing! He had verified it personally. He had handed it to someone he trusted, and told her to use it when it was needed. He had been right that it would hold. I called James that night, Karen's associate who had been present at the hearing. Then I called my own children, both of whom had known some version of what was happening and deserved to know how it had resolved. Then I sat in the chair for a while longer, with the house quiet around me and the November dark outside the window. Curtis called me the following Saturday morning. I answered. He said, "Michael, I need to say something." I said, "Go ahead." He said, "I was wrong. About what I did, and about what I believed I was owed, and about the last 3 years of Dad's life. I can't undo any of it. I'm not asking you to do anything about it. I just need you to know that I know." I said, "I know you know." He said, "Was he really thinking about that Thursday?" I said, "It's in the video. He talks about it for about 45 seconds. I'll send you the file if you want to see it." He said, "I want to see it." We talked a few minutes more. When we hung up, I thought about what my father had said in the spring of 2022. Give it time. Give it space. I had given both. My father had given me the thing that allowed it to survive the time and the space. The truth, documented and preserved and ready when it was needed. The legal consequences for Curtis are proceeding through channels I am not going to detail here, because they are his to manage, and their outcome will be what it is. What I can tell you is that the Fisher Park Circle house is in the process of being settled into the estate in the way that my father intended, and that I have been spending time there on weekends clearing and sorting, and in some cases simply sitting in rooms that held decades of a life well lived. I found the inspection checklist my father used for furniture pieces before they left the warehouse. He had laminated a copy at some point in the 1990s and kept it in the desk drawer in his study, which is where I found it, going through the desk paperwork. The checklist was exactly what I would have expected, specific, sequential, signed at the bottom by the inspector, which in the early years was my father's own signature, and in the later years was the inspection manager he had trained and checked for 2 years. The last item on the checklist said, "Confirm structural integrity before release." He had been confirming structural integrity his whole life. The furniture, the business, the estate, the 14 minutes in a chair on an August afternoon. He built things that lasted, and he verified them personally, and he did not release them until he was certain they would hold. The last thing he built held. If this story stayed with you, drop a comment below and tell me which moment hit you the hardest. Hit that like button, subscribe if you are not already here, and I will see you in the next one. True Story uploads every week. Subscribe and hit the bell so you never miss one.